Prince Andrew's lawyer has argued that the sexual assault case against him should be dismissed because it is baseless, a court heard on Monday. The Duke of York's attorney Andrew Brettler told the federal court in New York that the lawsuit filed last month was a non-viable and potentially unlawful case. Brettler, of powerhouse Hollywood law firm Lavely Singer, said that Andrew had not actually been served papers filed by his accuser Virginia Roberts. In court documents filed last Friday, Roberts's lawyers claimed that the prince had been served on August 27, when the paperwork was handed to a policeman at the gate of Royal Lodge in Windsor who said he would pass them on. The hearing is the first since Roberts, 38, sued Prince Andrew last month, alleging she was forced to have sex with him when she was 17 under the legal age of consent. It was not clear if the royal was listening in, but a man and woman speaking in English accents were heard speaking ahead of the court hearing. We do contest the validity of service to date. The Duke has not been properly served under either UK law or pursuant to the Hague Convention, Brettler told the court Monday. We have significant concerns about the propriety of this lawsuit that's been filed. We've been in correspondence with the High Court in the UK, and the High Court in the UK is going to have to determine whether service to date has been effected properly on the Duke. We believe this is a baseless, non-viable and potentially unlawful lawsuit that the plaintiff has filed. There has been a settlement agreement the plaintiff entered into in a prior action that releases the Duke and others from any and all potential liability. The case was delayed for about a week for Roberts's attorney David Boies to make any requests to the court for help with service. But Judge Lewis Kaplan had a warning for all parties, including the prince: there is a very swift way of getting to the substance promptly, but you two, lawyers, need to talk about that because I can see a lot of legal fees being spent and time being expended and delay which ultimately may not be terribly productive for anyone, the judge said. During the 30-minute hearing, Roberts's lawyer David Boies said that in his view, Andrew had been served under Article 10 of the Hague Convention. Boies said that it's clear Prince Andrew has actual notice of this complaint and proceeding. Brettler tried to argue that the senior master of the High Court in Britain needed to weigh in as the next step in the case under the terms of the Hague Convention. Judge Kaplan had little time for this and said that Brettler was making this a lot more complicated than it really is. Brettler responded that the rules under Hague Convention should be followed, to protect a foreign national. But Judge Kaplan said that I'm sure you know that the Hague Convention is optional, adding that service could be effected upon a foreign national under a U.S. federal rule known as 4(f)(3) without involving the government. That rule offers wide scope for serving a foreign person by other means not prohibited by international agreement, as the court orders. Judge Kaplan said that he would likely grant that order and was unlikely to change my mind unless I hear something new. The judge told Brettler that there was a lot to be said for Boies' point of view that you have a pretty high degree of certainty that he, Andrew, can be served sooner than later. Judge Kaplan said, let's cut out all the technicalities and get to the substance. Before the hearing ended, Brettler tried to broach the issue of the settlement agreement. It was signed by Roberts in a 2009 settlement with Jeffrey Epstein and was used by U.S. lawyer Alan Dershowitz to have a battery allegation she filed in a civil case against him dismissed. Brettler called it a secret settlement agreement that could release the Duke of any liability, as we suspect it does. Boies said that making such a request to see the document now was a bit premature and said that he disagrees with the characterization made by Brettler about what the document contains. Judge Kaplan declined to order Boies to hand it over as another judge in a separate case was making that decision. The case was delayed for around a week for Boies to make any requests to the court for help with service, including potentially having the judge asking British officials to assist. Judge Kaplan gave Brettler 2 weeks from the date Boies files his request, if it comes, to make any motions in response. Both sides were given dates to file additional motions to the court before an in-person hearing which was scheduled for October 13. Earlier on Monday, just 4 hours before the hearing was set to take place, Brettler filed a notice saying he would be representing the British Royal. Brettler stated that he was appearing for the purpose of contesting purported service of process and challenging jurisdiction. It comes after the high-powered attorney was hired to defend actor Armie Hammer, 35, earlier this year against allegations that the actor has cannibalistic fetishisms and sexually and physically abused a woman during their 4-year relationship. His other clients include director Bryan Singer, who has been accused of sexually assaulting minors. In an interview with The Hollywood Reporter in May, Brettler spoke out against the Me Too movement and said there was an assumption of wrongdoing just based on an accusation, even an anonymous one. But in another interview he said that sometimes the best response may be to lie low. Sometimes the best defense is to not do anything, is to accept the punishment or whatever decision it is that the company made and stay quiet and better yourself as a person. Make whatever apologies need to be made, privately, he said. Hiring Brettler brings the formidable resources of Lavely and Singer, founded by powerhouse celebrity attorney Marty Singer, onto Prince Andrew's legal team. Singer has been dubbed the Hollywood lawyer who can make any problem go away. Among those who have turned to Singer during times of crisis have been Charlie Sheen and Bill Cosby. Among the others he has represented include Michael Jackson, Tom Hanks, Naomi Campbell, Demi Moore, Eddie Murphy to name just a few. Prince Andrew is expected to appear in court Monday after reports last week revealed he was served with the paperwork for the lawsuit on August 27 at Royal Lodge in Windsor by a private investigator hired by Virginia Roberts' attorneys. The Duke's lawyers later disputed this and claimed that giving the document to a policeman at the gate of the property did not constitute proper service, legal filings state. Andrew has repeatedly denied any wrongdoing and claimed in an interview with the BBC's Newsnight show in 2019 that he has never even met Roberts. Roberts alleges that she was forced to have sex with the Duke 3 times when she was 17 at the orders of the late paedophile Jeffrey Epstein, a former friend of Andrew's. Court documents filed last week revealed the multiple ways Roberts's lawyers tried to serve Andrew with the papers, beyond sending an investigator to Royal Lodge. That included sending copies of the complaint and summons to 6 different lawyers from 4 different companies they believed represented Andrew. They sent the same documents to his public email account and sent them via post and FedEx to his address. Court documents show that Andrew's lawyer Gary Bloxham, of London-based Blackford's solicitors, claimed that did not constitute proper service. According to court documents, Bloxham told Boies in a September 6 letter, "We reiterate that our client reserves all his rights, including to contest the jurisdiction of the U.S. courts, including on the basis of potentially defective service." Boies, however, said in a legal filing that it was absurd to claim that Andrew did not know he had been sued. He wrote, "Attorneys at Blackford's, who he has apparently instructed to evade and contest service, have confirmed that Prince Andrew himself already has notice of this lawsuit and is evaluating his chances of success." The lawsuit claimed that Andrew was one of the powerful men who Epstein loaned Roberts out to for sex. It said, Prince Andrew's actions constitute extreme and outrageous conduct that shocks the conscience.
Prince Andrew's sexual abuse of a child who he knew was a sex trafficking victim, and when he was approximately 40 years old, goes beyond all possible bounds of decency and is intolerable in a civilized community.
The lawsuit accused the Duke of York, 61, of publicly feigning ignorance about the scope of Epstein's sex trafficking operation and sympathy for Epstein's victims, then refusing to cooperate with the FBI, despite promising to do so. Roberts, who is now 38 and a married mother of 3 living in Australia who goes by her married name, Virginia Giuffre, alleges the first time with the Duke was at the London townhouse of Ghislaine Maxwell, Epstein's alleged madam. The second time, in early 2001, was at Epstein's New York mansion, and the third time was on Epstein's private island in the Caribbean. The formal allegations against the Duke are battery and infliction of emotional distress. Under the claim for battery, the lawsuit states Andrew's actions constitute sexual offenses as defined in New York law, including but not limited to sexual misconduct as defined as rape in the third degree, rape in the first degree. It also claims the Duke's conduct amounted to forcible touching, sexual abuse in the third degree, and sexual abuse in the first degree. The lawsuit states that Roberts has suffered extreme emotional distress, humiliation, fear, psychological trauma, loss of dignity and self-esteem, and invasion of her privacy. Epstein hanged himself in 2019 while awaiting trial, and Maxwell is due to go on trial in November for procuring underage girls for him, allegations she denies.